I'm pleased to be part of the sizable embassy to this symposium from the Justice Department, and I want to assure you that it is not true, as Floyd Abrams was heard to mutter at lunch, that we all arrived together on a plane with two right wings. But at the hospitality suite last night, I was asking members of the Society about the purpose of the Federalist Society. And I discovered that there are three theories which vary according to ideological predilections. The Russell Kirk traditionalists take it as a matter of faith that the Federalist Society has a purpose, but believe that purpose to be unknowable. The Milton Friedman libertarians believe that the Federalist Society may well have a purpose, but that this is largely irrelevant to the ongoing workings of the market. And the Frank Meyer, Bill Buckley fusionists believe that the Federalist Society has a purpose and that it does not have a purpose. But I take it that there really is a purpose to the Federalist Society, a common thread that runs through their proceedings and their membership. And it's a purpose that, with respect, I think some of our commentators in the audience on the rostrum have perhaps not fully understood. I've noted, and I'm sure you did, some of the appeals to the libertarian or conservative or liberal or whatever substantive political principles of the audience in order to drum up allegiance for this or that reading of what is a desirable regime under the First Amendment. But the purpose of the Federalist Society, as I've come to know it, at least in part, is to advocate treating the Constitution as fundamental law, and precisely as law, and to ask the question, what have the governed consented to in the agreement they drew up among themselves? The Federalists reserved the question of what is desirable regime for the amendment process. This panel will address the First Amendment's recognition of associational rights. It's one of the few places where the Constitution deals neither with the formal structural arrangements of the government itself or fundamentally and directly with the relationship between the state and the individual, but rather addresses itself to the relationship between the state and the group. That is to say, between the state and the community of communities that comprises our culture. In that context, it's noteworthy that the associational rights provisions are specifically addressed to the right of the people peaceably to assemble. This protection of the right to form voluntary groups is critical to the enterprise of the framers in two respects. First, and most obviously, in political terms, the associational rights clause is important as a bulwark against the state. It furthers the dispersal of power that we see in other provisions of the Constitution, namely those setting up the three separate branches and restricting the national government to enumerated powers. But also, the protection of associational rights is critical for another reason. The formation of voluntary communities permits us to fulfill a fundamental aspect of our nature, the sympathy and cooperation with our fellows. In that sense, protection of associational rights goes not only to the political means of establishing a society in which we'll be able to fulfill our natures, but also is intimately related to the end of the establishment of that society, community life. To discuss this topic, the Federalist Society has assembled four distinguished commentators, and as something of a surprise move, we will go in the order that is printed in the program. Our first commentator is Judge Frank Easterbrook of the Circuit Court of Appeals for the Seventh Circuit, a man frequently cited at panels of the Federalist Society. He was professor of law at the University of Chicago and remains a senior lecturer at the law school. He's written a book on antitrust with Richard Posner, and as well as Judge Easterbrook himself puts it, has written numerous articles, some of them scholarly. He was also Deputy Solicitor General of the United States and, of course, argued many cases before the Supreme Court, a datum which indirectly led to the alienation of the entire class of law students at the University of Chicago, where he is said to have remarked to his first set of students that he was a little nervous before so large a class because he was used to teaching an audience of 9. Judge Easterbrook.
Freedom of association is, in some ways, a very strange topic for the Federalist Society. It's strange because one can look very hard in the Constitution and not find it. The First Amendment, after all, was an afterthought. It's okay as an afterthought because it was, after all, drafted by Madison. But if you look in the First Amendment, you find 3 group rights which are distinct from a broad right of association. There is, of course, freedom of the press, which is just another way to describe the exercise of the right of speech by organized groups. There is freedom of religion, which is another way to describe another organized set of group speech. And there is finally freedom of assembly, which turns out to be the organized exercise of the right to petition for redress of grievances. And the first Supreme Court case that even mentioned the freedom of assembly treated it as just that. It was that people could get together and jointly exercise the right to petition. That was a case in 1866 called Presser against Illinois, which thought the freedom of assembly so clear it didn't require more than 1 sentence. And that was essentially all there was on the freedom of assembly until this century. Now, given the fact that the First Amendment contains in it 3 express rights of group speech, there's a logical general right to associate for the purpose of speaking. That is what these 3 specific rights are about. And it's really quite irrelevant whether you call a particular association the press or exercising the right of assembly. In any event, they are jointly exercising the right of speech. But the interesting question is whether there is a broader right of assembly, a general right to assemble in security against the state, to withdraw in some sense into a private sphere, a way in which it is increasingly being used today. That, it seems to me, is fundamentally not a First Amendment right at all, but more properly part of liberty under the due process clauses, one in the Fifth and one in the 14th Amendments. A right of liberty to do what you please unless the government by legislation tells you to stop. The embarrassment to most descriptions of the right of association is that the government, especially state governments, has lots of legislative powers. And what people mean when they usually talk about the right of association is not a right to do as you will unless the government tells you to stop, but instead a right to override the government's legislation telling you to stop. A trump, something different from the right to associate to sell milk for $1 a quart. It is fundamentally a right to trump legislation. And trumps have a different problem, because they get created the way Mr. Justice McReynolds made up one of the first associational rights in Meyer against Nebraska. They get created through the method of substantive due process. In fact, the court is increasingly these days conceding that that is the true meaning of the right of association. In a case about 2 years ago, Roberts against the J.C.'s, Justice Brennan started his description of the right of association by saying, this is obviously one of our most precious rights. There's the right to associate for speech and the right of intimate association based so securely, as we all know, on Roe against Wade. For this organization to celebrate a victory of substantive due process flying the flag of the First Amendment is considerably to change its stripes. Now, maybe this is a little unfair. Maybe you can imply all that's necessary for rights of association, rights to be free of government, from the First Amendment. And the method by which you do that is to say the right to speak and petition would be worth less if it did not include a right to associate with friends and business partners. Now, that form of argument is probably right as a logical matter. Take, for example, a non-speech version. The corporation makes economic activity more effective. By parity of argument, free association makes political activity more effective. Since the First Amendment is largely about political activity, it must imply free association. And since associations are more effective to the extent they engage in things other than speech. Indeed, associations are probably most effective when formed for reasons other than speech. It must follow that the right of association principally protects associations formed for purposes other than speech, QED. An argument of that stripe was the sort of argument Justice Harlan used in NAACP against Alabama in 1958, the first case to recognize an independent constitutional right of association. Alabama wanted to bust up the NAACP, which was assembling, speaking, and petitioning all too effectively. The court's reply was that association is protected to the extent it makes rights more effective, and now the only question is whether particular forms of association would indeed make rights more effective. Of course, everybody applauds NAACP against Alabama these days. They applauded it then. It was a unanimous decision. It's praised today, and people have tried to use it as a fundamental premise for understanding the scope of individual freedom from regulation. But I think that's all the more reason why we should be skeptical about it. The rights that we all like are also the ones that will be taken care of by legislators, and it then becomes very easy for the court to say in an aberrant case that the judges are the true guardians of the spirit of the people. It's obvious that the legislature, had it thought about this, would have taken care of it. We're just doing it in their name. What that process produces is a constituency for judicial revisionism. It produces a powerful constituency when judges speak in the names of very popular results, very popular end states. And a court which has figured out a way to assemble for itself a powerful constituency is a court that then can legislate in further ways that would not win legislative assent, that cannot be portrayed as aberrant episodes, and to assemble its constituency for the popular rights against attacks by those who think there is something suspicious about what it is doing on other fronts. Or to put it slightly differently, the easy case, the popular and obviously right cause, may end up producing the most dangerous doctrines. The easy cases allow the judges to set off in pursuit of their own values and to assemble a constituency that will protect them when the values that they are pursuing are not to be found even in the penumbras of the document. And often, by the time they are done with the doctrine, it becomes very difficult to recognize as one that simply fortifies the original right under consideration. Consider what's actually happened with some of the right of association cases to the extent they're related to the First Amendment. In NAACP against Alabama, the court had no trouble saying that the NAACP was assembled and associated for the purpose of exercising First Amendment rights, to praise the way in which those are being exercised, and to sustain the claim. But to have started the inquiry in that way assumes that the first task for the court is to determine whether the associational goals are praiseworthy. And that can be a very dangerous inquiry indeed. And think about the case that I mentioned a moment ago, Roberts against the JCs from 2 years ago. The JCs formed an organization from which they excluded women. In the JC's case, the court started with every justice assuming that there was, of course, a constitutional right of economic association, and then the only question is whether the state had proposed a very good reason for overriding that constitutional right of association. Whether the state had proposed a very good reason turned out largely to be the question whether the court agreed with the legislation that was being applied to the JCs. It did. The exclusion of women is, for very good reasons, neither popular nor right. And so, a unanimous Supreme Court said that was good legislation overriding the right of association. And if you look at the history of the First Amendment right of association, it looks very much like that. In Buckley against Vallejo, the Supreme Court says that the right of political association can be overridden to the extent we think it prudent or wise to regulate, to avoid excessive wrongdoing with legislative candidates. In Runyon against McCrary, the Supreme Court said that Title VII could be applied to a private school because it was vindicating very important private rights. On the other hand, until there was a big change in public opinion, unions were unlawful in most states, and most people thought there was nothing wrong with that under a freedom of association. And the malleability of the doctrine was clear even in one of its earliest encounters, although it's not now phrased as a pure right of association case, the Jaybird primary cases. I mean, the Jaybirds formed a private organization in which they would hold primaries to determine who would be candidates in the Democratic primary. And they, of course, excluded blacks. That was part of their idea, to choose candidates who could be elected beholden to a constituency in which there was no black voice. The Supreme Court held that the Constitution compelled the Jaybirds to be open to blacks on the ground that this would change their political choices. And the Jaybirds were designed to mold political choices in a certain way. The Supreme Court saw that the exercise of that kind of associational right would have the intended effect, and therefore the holding was they have to be open because the openness will change the political effect and in a direction that we think is beneficent. Well, that may well be so, but by the time you're done with this series of attempts to invoke the associational right, it has changed from anything like a neutral principle of freedom from governmental intervention to buck up the right to speech to a purely utilitarian right of the sort that Jeremy Bentham might have invented, but a right of the sort that it's very difficult to believe that Madison would have invented. Now, perhaps this makes me the Grunch who stole Christmas, but I'm profoundly skeptical of any claim of constitutional right that acquires that malleability in which the nature of the doctrine turns on whether the court likes or thinks that underlying legislative power or claim is important, and in which it then proceeds to weigh associational claims against legislative claims in much the same way a very careful legislator would do. Now, I want to be very clear. I'm not for a second denying that association is valuable. Associations, private associations, are countervailing centers of power, private responses to the power of Leviathan. Totalitarian states start by tearing down private associations because they understand how dangerous they are. And of course, private associations can be dangerous in two ways. One of the things the current wave of deregulation is doing is trying to tear down some kinds of private associations. Take, for example, rate bureaus, private associations whose principal point was to see if they could get monopoly prices for something. The point is not that things are not important, but that when the right can only take the shape of an extrapolation from constitutional values and is then suffused and defined by how important we think it is, that it is no longer on safe ground as a constitutional right at all. What is the right? What is the constitutional right of association? I think it is an exercise in the right of speech, that people who associate for the purpose of speaking have one of the three rights that is directly stated in the First Amendment. But to the extent the association is justified merely on the ground that people may be counterweights to Leviathan, it lacks a sound constitutional footing. This is a short talk, and I don't want to take on the question whether judges ever ought to look to constitutional values rather than to structure and history. It seems to me enough for now to say that the associational right is one without textual or historical foundation, and it can't be construed without using the method of substantive due process. But I think it's important in thinking about this kind of problem always to bear in mind that when a judge invokes a constitutional right, he must be making a special kind of claim of justification, the kind of reason a judge must offer when he asserts a right to upset the work of the political branches must fundamentally be that there has been an antecedent decision external to the judge or external to his conclusions about the utility of the statute at hand. That claim of external decision is usually founded as a claim to the original meaning, that is, that our fundamental compact decided it. As the associational right has developed, it has become less and less possible for judges to make any such external claim. The claim that there is an associational right to speak is one that is well-founded. The claim to the particular form of embroidery that we now see is not one that is well-founded, and I think we should therefore all be fundamentally skeptical of seeing this form of extension.
Our second commentator is Professor Randy Barnett of the Illinois Institute of Technology, Chicago, Kent College of Law. He has been a research fellow at the University of Chicago Law School. He's a fellow of the Institute of Humane Studies. He is an adjunct scholar of the Cato Institute. Professor Barnett is published extensively in scholarly journals. He's a graduate of the Harvard Law School, which he's careful to point out was in the Ancien Regime.
It was in transition. Roberto Unger was my contracts teacher, so he wasn't that ancient. I was trying to figure out for several weeks why I had been invited to participate. And by the way, I want to thank the Federalists for inviting me to participate. I have very much enjoyed the conference, at least up to this point. I couldn't come up with any particular reason since I don't teach constitutional law and I haven't really written about constitutional law very much. And it wasn't until I got here that I realized what the explanation was. And that is that apparently by this panel, they had run out of available University of Chicago law professors. And since I'm from Chicago, and since the word Chicago is in the name of my law school, that was close enough, and that's how I got invited. Well, apart from my lack of background in the area, there is another reason why I am uncomfortable about speaking about discussing constitutional rights, including an alleged right of associational freedom, and that is that I find much of contemporary constitutional thought assuming that the only rights that individuals have are those that they are given by the legislature or those that are explicitly specified in the Constitution of the United States or in a state constitution. Such a view of rights is based on the jurisprudential philosophy known as legal positivism, a view that has dominated academic discussions of rights and legality for at least 50 years, if not longer, and which only in the last 10 years or so has been called into question. In my remarks today, I will try to show how adherence to this legal philosophy taints constitutional discussions in general and discussions of associational freedom in particular. Now, legal positivism specifies that the only legal rights one has are those which are recognized by the sovereign legal authority. While one may appropriately claim that a sovereign legal authority ought to recognize a right, according to a legal positivist philosophy, unless and until such a right is in fact recognized, we cannot say that the individual has such a right. In other words, legal positivism represents the view that first comes government, then comes individual rights. This jurisprudential position connects with constitutional analysis in two ways. First, if the source of law is the sovereign, and if, as in the United States, the sovereign is thought to be the popularly elected legislature, then unless the legislature grants a right to an individual, that right cannot be said to exist. True, in the United States, this legislative supremacy is qualified by a constitutional framework, which places judicially enforced limits on what legislatures may permissibly do. But the Constitution itself can also be seen as nothing more than the positive law of the sovereign body known as the Constitutional Convention, as ratified by the various states. Viewed from a strictly positivist perspective, then, judges are authorized to recognize only such rights as are generated by a popularly elected legislature or by a written constitution, because these two institutions are the exclusive sources of all rights. A judge may never restrict the acts of a duly elected legislature unless specifically authorized by the Constitution. A judge is only authorized to enforce those strictures which are actually written in the Constitution and those which may be fairly implied. I shall call this the government first, rights second approach to individual rights, and the Constitution, I would call that the view of the Constitution that stems from this view, I would call the Austinian Constitution, or the Austinian view of the Constitution, after John Austin, the father of legal positivism. At this point, perhaps I should briefly explain the older view of law and rights that may be contrasted with the legal positivist view of the Constitution. For I am afraid that the Austinian approach to the Constitution is so well established that many of you may not be able to even conceive of an alternative to it. There was once a time, however, when legal and political thinkers began, rather than concluded, their political and legal analysis with the proposition that individuals had rights, natural rights, if you will. John Locke was one of these thinkers. And here's the way the theory went. In a state of nature, that is, in a society where there is no government, quote, all men may be restrained from invading others' rights and from doing hurt to one another, and the law of nature be observed, which willeth the peace and preservation of all mankind, unquote. Putting Locke's point in more modern terms, Robert Nozick's terms to be precise, we might say that the starting point of a Lockean political and moral analysis is that, quote, individuals have rights, and there are things no person or group may do to them without violating their rights. Now, where does government come in? Again, quoting Locke. Civil government is the proper remedy for the inconveniences of the state of nature, which must certainly be great, where men may be judges in their own case, since it is easy to be imagined that he who was so unjust as to do his brother an injury will scarcely be so just as to condemn himself for it. In other words, government is created because it is convenient. It solves some difficult practical problems of rights enforcement. Government is not seen, according to this view, as the source of rights, but rather pre-existing rights are viewed as the reason why a government is created. Therefore, not just any government will do. As Locke observed, if government is to be the remedy of those evils which necessarily follow from men being judges in their own cases, and the state of nature is not to be endured, I desire to know what kind of government that is, and how much better it is than the state of nature. In other words, if government is a cure for some malady involving the protection of individual rights, it must be a cure that is better than the disease. And our standard for assessing the performance of government are the pre-existing rights of the individuals. According to this view, then, individual rights come first, and government, with all its various branches and federal-state separations, comes second as a means of securing these pre-existing rights. Now, this view of law and rights in government might strike many of you as being nothing more than ancient philosophy, like listening to stirring passages of Aquinas or Aristotle, or perhaps, more accurately, the ancient sophists. What could all this possibly have to do with modern, indeed with contemporary constitutional jurisprudence, much less with associational freedom? Well, the connection lies, I think, in the fact that the authors of our Constitution were very much influenced by the Lockean philosophy of rights first, government second. The founders clearly saw that the creation of government, all three branches of government, requires limits on the power of government, what we call constitutional limits. And the constitutional limitations imposed on the executive, the judiciary, and yes, on the legislature as well, must protect the natural rights of all persons who comprise society. Now, Judge Bork has recently and wisely admonished us that, quote, judges have no mandate to govern in the name of contractarian or utilitarian or what have you philosophy, rather than according to the historical Constitution, unquote. So the connection I am asserting, to use Judge Bork's term, is that the historical Constitution may most accurately be seen as a product of this Lockean rights-first philosophy. In fact, to interpret the Constitution from a legal positivist or Austinian perspective of government first, rights second, leads to a danger of treating the Constitution as a product of 19th century philosophy. After all, the great John Austin did not deliver his lectures in jurisprudence until 1826, and they were first published in 1832, some 40 years after the Constitution of the United States was adopted. And yet, until the mid-70s, the Austinian Constitution and the government first, rights second view of rights on which it is based dominated constitutional thought. What accounts for the almost complete eclipse of the rights first, government second philosophy of John Locke and the historical Constitution? While the answer to this question defies a simple explanation, at least three factors were important. The first was the acceptance of Austinian legal positivism by American intellectuals as part of the empiricist movement that swept all branches of academia in the 19th century. Empiricism has been defined, I take this definition from the Encyclopedia of Philosophy, as, quote, the theory that experience rather than reason is the source of knowledge, unquote. In short, according to this view, if you cannot see it, feel it, or measure it, it isn't real. And the most palpable aspect of law is the actual enforcement of it, and therefore that is what we define law to be. Certainly to an empiricist, any talk about natural rights or natural law is nonsense, to use Jeremy Bentham's famous phrase, and any talk about natural rights is nonsense on stilts. No one better exemplifies this approach to legal analysis, I think, than Justice Oliver Wendell Holmes. Holmes's famous statement that, quote, the life of the law has not been logic, it has been experience, perfectly captures his empiricist orientation. Holmes characterized notions of substantive due process based on pre-existing individual rights as positing, quote, a brooding omnipresence in the sky, unquote. In Lochner versus New York, he dismissed the majority's Lockean reasoning, which was based on the historical Constitution as modified by the 14th Amendment, with a phrase that became the rallying cry for 20th century constitutional law. Quote, "The 14th Amendment does not enact Mr. Herbert Spencer's social statics." Now, even for Holmes, the master of judicial put-downs, this put-down was truly brilliant. By making it appear to be a product of Herbert Spencer's popular but radical English book published in 1851, the majority's Lockean analysis was deprived of its historical legitimacy. In so doing, the way was paved for a more, quote, modern constitutional analysis based on the 19th century Austinian and essentially utilitarian view. And we must remember that John Austin was close compatriots with Jeremy Bentham and James Mill. And this was the legal philosophy favored by Holmes and others. And what made this all the more incredible is that it was all accomplished in the name of philosophical neutrality. The second blow to the Lockean historical constitution based on rights first, government second was, as we all know, the Great Depression and a general perception that this was a product of the failure of classical liberal principles, or at the very least, that dealing with this catastrophe required a scuttling of liberal principles. As the Japanese detention cases illustrate, we cannot underestimate the effect that general fear and perceptions of exigency may have on constitutional jurisprudence. Finally, the Lockean background rights that had sometimes been inconsistently upheld by the court, later making the doctrine appear less intellectually compelling and easier to reverse. In truth, serious problems of application in this area are probably unavoidable, but for reasons which go well beyond the scope of this presentation. But history has shown that the Austinian alternative is not a superior one. In fact, beginning in the 70s, the doctrine of substantive due process was rehabilitated by such writers as Gerald Gunther and Lawrence Tribe, causing the positions of those on the left and those on the right to reverse. Modern liberals now use substantive due process in the language of entitlements, both to protect certain basic personal, as opposed to economic liberties, and to defend the welfare and regulatory state from the powerful intellectual and popular assault that classical liberals and conservatives have developed in recent years. Ironically, today, many of those on the right who reject much of the so-called progressivism of the New Deal completely accept the legal positivist constitutional theory that was used to bring the welfare and regulatory state into existence. Let me now briefly try to explain what all this has to do with freedom of association. The freedom to associate with persons of one's choice, which also includes the freedom to refuse to associate, could hardly be a more basic component of the freedom to order one's own life, which natural rights serve to protect. But if one is going to take a strictly Austinian or positivist view of the Constitution, how are such freedoms to be protected from legislative encroachment in the absence of a specifically applicable enumerated constitutional right? The answer is that the court must either find some enumerated constitutional right, or at least a penumbra or an emanation from a constitutional right, or forever hold its peace. But what enumerated right would apply? In the three famous cases of NAACP versus Button and Buckley versus Vallejo and Brown versus Socialist Workers 74 Campaign Committee, the Supreme Court quite reasonably held that the legislation in question threatened the enumerated constitutional right of free speech that each association exercised on behalf of its members. But the recent case of Roberts versus United States JCs could not be similarly resolved. In that case, the National JCs, a purely non-governmental association, had attempted to exclude women from its membership. Unable to find that the JCs engaged in much of any constitutionally protected speech, something that is probably true of most, or many at least, private associations, the court concluded that this application of the Minnesota statute against sex discrimination did not jeopardize the enumerated First Amendment right of free speech and therefore was permissible. Notwithstanding that the founders would likely have abhorred this kind of governmental interference with a private association had they ever even imagined such a statute, in the name of strict constructivism or judicial restraint, or what have you philosophy, to again borrow Judge Bork's felicitous phrase, the Supreme Court of the United States must supinely countenance this kind of legislative usurpation. A Lockean approach to the Constitution would consider two types of rights as being capable of overriding legislative action. The first is the specific institutional rights that our particular constitutional framework explicitly provides to protect the individual from the government it creates. The second type of rights are the background rights that each person has by virtue of their being a human being living in society, rights which government is created to protect. Do we have a right of freedom of association, and if so, is it an institutional right, a background right, or both? it is probably not too difficult to find an institutional right of associational freedom based in the First Amendment's explicit guarantee of free speech, as the court held in Button, Buckley, and Brown, and those three decisions I just mentioned. And this institutional right probably does fall short of protecting the associational freedom of the national JCs, at least if the court's characterization of the JC's speech or non-speech activities is accurate. But a Lockean approach identifies certain more fundamental background rights as well, rights which do not simply evaporate upon the creation of government. We may call these rights, to use Locke's term, property rights, that is, rights to acquire, use, and transfer ownership to resources in the world, and they are the principal means by which life, liberty, and the pursuit of happiness are to be facilitated. Such rights include not only the right to external resources, but also the right to one's person. As Locke put it, every man has a property in his own person. It is then at least possible that the application of the statute in Robert versus United States JCs violated the background property rights of the national JCs. Persons who, like the national JCs, expend their own rightfully and privately acquired resources on non-governmental activities need not admit into these activities persons with whom they do not wish to associate. So while we may not have a background right of associational freedom per se, associational freedom is an important aspect of the rights we do have. The only obstacle remaining in the path of judicial intervention on behalf of the JCs is to justify federal judicial intervention with a state legislative act. Of course, the 14th Amendment permits such an intervention when a state deprives a citizen of life, liberty, and property without due process of law. To strike down a legislative infringement of Lockean property rights, a court does not need to incorporate the Bill of Rights into the 14th Amendment or find emanations and penumbras. A proper theory of substantive due process would support federal protection, or at least could conceivably support federal protection of the property rights of the JCs. Now, I know that many of you are saying to yourself something like this: wait a minute, call it legal positivism, or the Austinian Constitution, or government first, rights second, or whatever you like. I still want to know, what gives an unelected federal judge with lifetime tenure the right to thwart the will of a popularly elected legislature without express constitutional authorization? Do I know my audience, or do I know my audience? A fair question. So let me close by reading you another passage from the historical Constitution. Quote, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." Now, I am sure that you recognize this language as coming not from Robert Nozick's Anarchy, State, and Utopia, but rather as the 9th Amendment to the Constitution enacted in 1791. Now, notice that the amendment speaks of rights which are, quote, retained, unquote, by the people. I submit that such a phrase would be completely inexplicable to a government first, rights second philosophy of an Austin or even a Holmes. Any such claim would have been viewed as nonsense on stilts by Austin's mentor, Jeremy Bentham. And yet there it is in black and white. I submit that some of the framers realized all too presciently that enumerating the powers of the federal government would not alone be enough to prevent the government from violating the individual rights it was created to protect. They therefore inserted an amendment referring to the, quote, rights retained by the people, unquote, as a way of authorizing the enforcement of a Lockean vision of rights first, government second. And if that is correct, do not be surprised to find that associational freedom is protected by these fundamental background rights. But if, as a strict constructionist looking for the historical Constitution, you are reluctant to take this step, then it is my turn to ask a question. What do you interpret this explicit passage in the historical Constitution to mean? Perhaps I am speaking now as a contracts professor and not as a constitutional jurisprudent, but I find it very hard to believe that the framers originally intended to insert in their Constitution an amendment that meant nothing at all, which is the way it was taught to me. Given the tenor of recent philosophical discussions, many conservatives today shy away from all talk of entitlements. I notice I excluded classical liberals from that one. But by doing so, they are once again yielding the moral high ground to those who oppose many of our most basic and traditional rights. Of course, an open debate about fundamental rights creates the risk that misconceived rights will be enforced. But refusing to argue the issue in the name of philosophical neutrality is to unilaterally disarm. Such a posture is not only doomed to failure, it is contrary to the original intent of the framers of the historical Constitution.
One quick word. I hadn't anticipated when I filed a substantive due process indictment against the freedom of association that it would immediately plead guilty.
You come now, Judge Easterbrook, you're trying to interfere with Professor Barnett's assigning all the roles in this drama to himself. Professor Barnett, you can internalize the debate as well as any man I've ever met. Our next panelist is Grover Rees III, a native of Louisiana, a graduate of Yale College and the LSU Law School, where he was editor-in-chief of the Law Review. He has been a law professor at the University of Texas since 1979, taking a leave of absence during the last year to serve as the Attorney General's Special Counsel for Judicial Selection. I might add that the fact that Rocky was physically in Texas during the first term in no way attenuated his ability to inflict his opinions on poor public servants like myself. You see, in his own way, he is adept at holding the floor as Richard Epstein, but rather than merely talking faster than anyone else, Rocky has perfected the technique of breathing in the middle of a sentence so that he can run from the end of one sentence into the beginning of the next one without giving any opening to any potential rival. But I will say that I think it's an evidence of how seriously the Attorney General has taken the question of judicial selection that he's called on someone of Rocky's great understanding to administer this process for the government. And now we'll hear from Professor Rees.
Thank you. It was with some trepidation that I approached this panel because what I had to say was only tangentially related to the freedom of association. Therefore, I'm very grateful to Professor Barnett for having set the tone for the panel and having ceased to trepidate, I will say that the relation that this does have, that what I'm going to say does have to the freedom of association, is that I think that empirically, in terms of its actual effect on people's lives, the most important political association case in recent history was the case of Elrod versus Burns in 1976, wherein the court held that political patronage employees could not be fired by the new administration simply because they'd been hired by the previous administration based on their political loyalty and that they'd worked for the previous administration in the election and so forth. In other words, you couldn't have political patronage firing. Now, that case was to some extent derivative of a 1968 case called Pickering versus Board of Education, which had applied the same analysis to speech. That is, Oliver Wendell Holmes's old statement about public employee speech, that you do have a right to free speech, but you don't have any right to be a policeman, was modified to the extent that you couldn't at least be fired because you had spoken out on a matter of public interest. Of course, it wasn't that simple. There were three prongs, but that was the starting point in the analysis. Now, since Elrod and Pickering, there have been a number of cases elaborating the doctrine. I count about 8 prongs on the various cases, but I've managed to reduce it to 3 for both speech and association. That is, when can you fire a public employee? First of all, I should emphasize that we're not talking about civil service employees. Of course, if somebody is a civil service employee, he has got statutory rights, Austinian positivist rights that have been granted by government to his job, and he can't be fired. That is a contract, and he can't be fired within the terms of the contract, usually just because he's exercised some constitutional right. He's got to be fired for cause. But whether or not there's a civil service system, Pickering and Elrod and a number of other cases say that you can't be fired for having exercised the constitutional right to speech or association, political association, unless several things. And these aren't always either or, but the court will look at a bunch of things. And generally speaking, they will look first to see whether you might be within a narrow band of policymakers who are exempt from that. You know, the governor can fire his principal assistant if the principal assistant has come out and said that the governor's program is crazy, or if he has associated with people who are known to think that, perhaps, in a politically suggestive way. Secondly, is the speech or association of some importance to society? And this is where Judge Easterbrook's point comes in, that the court has to weigh the value to society of the speech or association, or is it primarily sort of a local parochial job-related dispute? And third, is there going to be some disruption of the workplace? Is there going to be some disruption of the workplace that merits the firing? Now, when I say that this was an empirically important case, I mean that that the plurality of all of the First Amendment cases that I've been able to find for the last couple of years in a couple of the circuits that I looked at, the greatest single batch of First Amendment cases don't have anything to do with the government going out and trying to prevent some private citizen from speaking. They have to do with the question whether some public employee has been fired for exercising his constitutional right to political association or to speech. Now, one reason for this is that around the same time that the court decided Pickering and Elrod and all of the progeny, they reaffirmed the doctrine that you can still fire a public employee for no reason at all. For any reason or no reason at all is the way the court says it. You don't have to have a good reason in general, but if it's speech or political association, you can't do it. And that has generated what we would think of as some odd results if we didn't have advanced training in legal analysis. In the recent case of National Gay Task Force versus Oklahoma Board of Education, the Supreme Court upheld on a 4-4 vote a 10th Circuit opinion that said that it was kind of vague on the first point, but essentially you could be fired as a school teacher for engaging in at least some kinds of homosexual activity. But on the other hand, you couldn't be fired as a school teacher for advocating homosexual activity, even illegal forms of homosexual activity. Now, again, I think that makes perfect sense if we're talking about what can be done to me as a private citizen, that is certainly a valid distinction and a correct one. I think it causes some problems in the public employee context, as I will talk about. There are a number of other interesting cases in the circuits. In one of them, the head of a community action agency had a dispute with the local, with the board of directors of the community action agency. He was the executive director, about whether he could be fired by them. They'd hired him, but he maintained that he had acquired some sort of a property interest in his job and couldn't be fired. And he took this to a public hearing, and he made this statement in a public hearing. They said, "You don't have the power to evaluate me, and you don't have the power to fire me." And they said, "Well, we are hereby doing both." Now, the court held an interesting set of things. They held that he was wrong about what he said. That is, if he'd never said anything, they could have fired him. But since he made the erroneous statement in public, and since that was what actually precipitated the firing, he couldn't be fired. At least the community action agency had the burden of proving, and these are the kinds of burdens that you rarely carry. Since it's hard to prove that you fired somebody for no reason at all, which you're entitled to do, when they did something that everybody knows you didn't like. So they had the burden of proving that they fired him for some other reason or for no reason at all, not because he got up and publicly challenged them at the public hearing. The second case that, this there are a wealth of cases, but I picked out several. There's another one where there's a director of vocational education in a local school system, and there was a hotly contested election having to do with the policies of the school board, and a new school board was elected, and they fired him. They fired this non-elective employee. Well, he maintained that they didn't have any right to do that because he hadn't done anything. He said, I was just the friend of the old school board, and that was the reason they were firing me, just because of who my friends were. Well, the district court held that he had argued exactly the wrong thing, because friendship is not a protected activity under the First Amendment. It's not a protected form of activity. Well, the circuit noticed that in the pleadings, although his lawyer hadn't really emphasized this, it was clear that the other side, in fact, had argued he was actually more than just their friend, he was their political associate too. He was, in fact, part of the problem that we were elected to fix, and that's why we fired him. And so the Fifth Circuit remanded, and they said, if he can prove that in essence the answer to his complaint was right, and that he was political, and that he wasn't just fired for his friendship, but for his political association and for his advocacy of the policies that the new board was elected to end, then he can't be fired. Now, this all makes perfect sense doctrinally, by the way. Now, my favorite case, however, is a case in which a president of a small college was getting anonymous phone calls between the hours of midnight and 3 a.m. A person would just call and then hang up. And so he had a tap put on his phone, and it turned out that the phone calls were being made by the dean of the college. Well, at least 3 of them had, the 3 that the police were able to tap. The dean said that he made those 3, but he didn't know anything about the others. A jury held, and it turned out that the dean and the president had a long-standing dispute over a union that the dean was trying to form, a teachers' union, and that the president was resisting. And the president was, in fact, trying to bust the union in various ways, and that this was a response to the union-busting efforts. Well, the jury found, the instruction basically said, if the political association, the union-forming activity, was a cause in fact, or rather, if he wouldn't have been fired but for that, then he can't be fired. And since he only made the phone calls after the president busted the union, it was a cause in fact and a but-for cause. He wouldn't have ever made those phone calls. At least that's my best reading of the jury verdict. It was maintained that he had a right to damages and attorney's fees. Now, that was what 2 judges on the Fifth Circuit held. The third judge, Judge Rubin, held, would have gone further and actually reinstated the dean of this small college there in his job. It was a question of his not being rehired, by the way. Decisions not to rehire are treated just the same as decisions to fire. If you weren't rehired for a reason having to do with political association, that's just as bad as being fired. And the burden is the same once you've gone out and committed that political association. Anyway, Judge Rubin, however, dissenting from the decision to remand to see whether reinstatement was appropriate, just would have reinstated him automatically since, quote, a college president not bent on vindictiveness would probably suggest to a dean who demonstrated such a reaction to pressure that he take a rest and consult a doctor. Now, I maintain that although the proposition that 3 a.m. phone calls should be made to unpleasant employers has great appeal as a matter of social policy and perhaps natural right, that what we see here is that you really are a lot better off if you've got a job with the government than if you had a job anywhere else, because you would almost certainly be fired for the 3 a.m. phone calls all by themselves with nothing else in virtually any other job that I can imagine. Now, what these cases show, it seems to me, is that the courts haven't paid sufficient attention to the differences, and this was a question I raised last night in response to some of the remarks of the speakers on the political process panel, the courts haven't paid enough attention to the difference, what I would regard as close to a category difference as there can be in a universe that's all full of continuums and not very many dichotomies, the difference between the government's action when it is deciding how to spend its resources and the government's action when it's trying to regulate the affairs of private citizens. And I don't claim that it's not very difficult to try to figure out what to do when, as I think Professor Stone said last night, so much of the resources that there are in society are being spent by government that to a great extent, you know, the relationship between citizen and government and the relationship between government employee, private citizen and government, and government employee and government can be much more similar than they might be in a society with a much smaller public sector. Now, this also has implications, not only in the speech and association area, but of course in the religion clauses area and in the taking of property area and so forth. It has implications for the question whether original intent analysis is coherent. Because I think if there's one thing that we're sure the framers didn't contemplate, it was a 40 or 50 or 80% public sector. Now, they didn't contemplate it, but I don't happen to think they made it unconstitutional. In other words, I think that we could have a largely socialist state that would not be unconstitutional. I understand there are people who differ on that point, but that would not be unconstitutional. Now, one solution, obviously, is to say that's where we went wrong. It is not only bad policy, it is the mother constitutional problem of all the little constitutional problems. You just declare socialism unconstitutional, you declare anything beyond a 3% public sector unconstitutional, and all these other problems go away, which I think they largely do. Because you see, in Holmes's day, when you had something like a 3% public sector, you could take his view of the relationship between the public employee and the society, and it was not particularly problematic. In fact, a government job of any kind was a big plum that it was easy to see that was very special treatment that you were getting. Within the court's three prongs, you could just say everybody was within that little narrow band of policymakers that justified a special need for circumspection, a special need for loyalty. Every government employee was a government official to whom we were all entitled to expect some kind of behavior. Or, by the way, you could have gone the other way. You could have said, no, every government official is entitled to speak and do anything he wants, and the effects on the rest of us would not have been that great, because there wouldn't have been that many resources deployed against our own speech, for instance, deployed against what we wanted. You could really have gone either way on the constitutional question with a small public sector, and you wouldn't have that many practical problems for people. Now, let's imagine the other extreme. Let's imagine that we get 100% public sector. Then it seems to me it becomes very obvious that we do have to treat expenditures of government resources just the same as we treat regulation of private citizens. Whether we're talking about free exercise and establishment analysis or political association. And if the government takes all the money that there is and then gives you back some money, I don't think they can tell you that you're not free to put it in the collection basket, for instance, or to restrict your speech as a consequence of your getting that money. The problem comes when we have, as we do, anywhere between a 35% and 45% public sector, depending how you count. And what the court has responded with is balancing tests. Now, people may say balancing tests are the only answer. You just admitted that it's all very confusing and maybe incoherent. The problem with the balancing tests is, at least with the ones we've got, is that it does tend to come down with the court deciding what the right result is and enforcing and invalidating decisions that are outside a narrow band of that right result. For instance, I would maintain that on education, on the question of education, we are a 100% socialist economy. That is, the government is taking away anything that anybody would reasonably expect you to spend on education at the elementary and secondary level, and they are spending that for you. They are, you know, I mean, if they took away all your money and gave you back chits, some of which were education chits and some of which were food chits, you know, you wouldn't get any more education chits than you're getting now. So if we can divide it up that way, I would say that they are taking all the education money, they're redistributing it, and then spending it all for you. And yet, the voucher cases under that analysis should have come out the other way. If in fact what the government were doing with all of your money was taking it away and then giving it back to you with government funds written on it, it seems to me they would have you'd still have a free exercise right, at least in certain cases, to send your kid to a religious school. And yet they really are taking away all of your religion money, or rather all of your education money. And they're not letting you spend that money on a religious school. They're saying it's unconstitutional even if the state wants to let you spend that money on a religious school. So I think the court hasn't been very careful. They have stuck to the old myth that this is really a 0 or a 1% public sector in analyzing the voucher issues. And yet, on the political association issues, they've really gone the other way. They have treated public employees as though they were no different from the average citizen, which, as I say, would be true if we had 100% public sector. Whereas, in fact, it's almost the opposite. In fact, when you get a 35 to 45% public sector is where the differences between the people who are ensconced in government jobs and the other people in the society matter the most. Because when you give special privileges to 35%, when you treat them, as in these cases I think I've shown that you do, when you treat those citizens differently from the other 65%, you have a quantitatively significant effect on the rights of the other 65%. You're a lot better off if you've got a government job in terms of being able to keep it and do almost anything you want than, at least in a political way, than if you've got a private job. And you can fight, and you will have more time empirically to fight, battles in which the interests of government employees are in one side and the interests of general taxpayers are on the other side. So it makes a difference to the other 65%. The second thing is it winds up with the institutions being run in ways that we would never dream of running private institutions. The fact is that most of the good reasons you can get fired, most of the reasons we all agree are permissible and desirable reasons to fire somebody in private enterprise have to do with something he said or with somebody that he associated with. And yet you can get fired for no reason at all if you're in government, and you can't get fired if you are if you've said something. And I think the final illustration that I'll use is the homosexual case where, you know, my own view as a parent of a 12-year-old is that I really don't care what my kids' teachers do in private, but, you know, as an antediluvian parent of a 12-year-old, I really do care what they tell him, or even what they tell somebody else that gets back to him, to the extent that those teachers are role models. And I think there's room for disagreement about that, but I think that it is not a crazy thing it is not a crazy or necessarily a mean-spirited thing to do, to say, I don't want any teachers who are sort of known for doing things that I really don't want my kid to do. Whereas I think it is kind of mean-spirited to try to root out the behavior and say, I don't want them doing it even if it has no effect on my kid. And yet the result comes out exactly the opposite under the doctrinal analysis that the court has applied. My own solution is that we should, for the time being at least, until we get up there around 100% public sector, restore to the people the right to choose whether they are going to have a patronage system with all of the evils that has and all of the advantages that has, or a civil service system, which was originally not supposed to be for the benefit of the employees, but for the benefit of society, with all the advantages that has and the disadvantages that has. Thanks.
The final panelist of the day is Maurice S. Arnold, United States District Judge for the Western District of Arkansas. He was formerly professor of law and history as well as vice president at the University of Pennsylvania. Judge Arnold was also Dean and Foskett Professor of Law at Indiana University Law School. He is the author of 6 books and many well-regarded articles on the subject of American and English legal history. Judge Arnold confided to me at lunch that his writings, which have ventured beyond legal topics, have sometimes ended less happily, so that right before the oil crisis of 1973, he predicted that energy would soon become a free good. Judge Arnold.
Thank you. Actually, I want to correct something our moderator said for 2 reasons, and I'll tell you what they are after I correct him. I didn't actually write that down. What I did was I said that once in public, but I was only repeating what my president said. And I don't mean our present president. I mean the president of the University of Pennsylvania. There are 2 reasons I wanted you to know that. First is that though it was a stupid thing to say, at least I thought better of it before I put it in writing. And the second is that I want you to know that I confess general ignorance when it comes to holding myself out as anything like an expert in economics or the matters of money. And indeed, you will probably guess that after you've heard what I've had to say today anyway. So I hope that in any event, this little disclaimer will serve as a kind of palliative to any negative reaction that what I have to say may generate. I think it is a bit ironic. Paul Bador has already spoken very eloquently about ironies today, that we are all sitting up here talking about natural rights and liberties and worried, and quite rightly, about the nature and extent and size of our government, and yet I think that we're all public employees, are we not? No, of course not. The natural lawyer is not. And that's altogether fitting. I was delighted, despite a few barbs that have been shot in the direction of Professor Barnett, by what he had to say, because I think it fits in rather nicely with my limited remarks this afternoon. I shall make some effort to stay within the 10-minute limit. I want you to know that one of the reasons I'm doing that is that I'm last on the program, and I know that most everyone wants to go home anyway, that is to say those who have not already done so. And I also want to reveal to you that this is the 3rd time in as many weeks that I've had the position of anchorman at a conference of this sort. Now, this emerging pattern must surely have some sort of message behind it. And if I were a better social scientist, I think I could probably tell you what it was. But in any event, you will mercifully be released after my few remarks, and I will appreciate your attention to them to the extent it's still possible. Discourse about rights these days, in law schools at least, tends to focus on the question of whether they even exist, absent their positive creation by some sovereign. In fact, it is probable that modern academic thought affords less respect to natural rights ideas than has been afforded to them in the past few centuries. So, for instance, my friend Dean Ely of this law school has written that except perhaps for the right to be free from battery, he is hard-pressed to think of any natural rights at all. So, too, Charles Freed, currently Solicitor General of the United States, has opined that he did not find the idea of liberty a particularly useful one around which to organize a political or moral philosophy. Judge Richard Posner, at one point at least, went so far as to say that moral rules are merely the product of the search for efficiency. Ronald Dworkin simply finds the idea of a right to liberty absurd. I guess this is enough to demonstrate that in the academy, at least, the idea of the moral rectitude of freedom is in bad odor and much in need of rehabilitation. So pervasive is this academic skepticism that it is not too much to say that law faculties have recently become intent on the complete dismantlement of the classical Western liberal tradition. Curiously, this is true, sometimes at least, of both right and left-wing thought. The utilitarians, for instance, or some of them at least, in the quest for efficiency, pay little attention to rights. To give but one example, and to simplify a great deal, if it could be shown to some of their satisfaction that X derived more utility from beating Y than Y suffered disutility from being beaten, then the act of beating is efficient and ought to take place. Any intervention on Y's behalf on the side of something called the so-called right not to be beaten would thus be rejected. So even Dean Ely's grudging recognition of the right to bodily security is pushed aside. Or take another example. Take the right to property, which the utilitarians so cavalierly assign to one party or to the other in order to compare the welfare or wealth output from one situation with the other one. The analysis ignores all of the considerations associated with traditional liberal thought, whether, for instance, the person deprived of the property might have in some sense or other earned it, whether there are degrees of merit, whether there is indeed anything at all to the concept of just property. At least this analysis spares us having to determine any individual person's need, a concept that is much deferred to by modern 20th century liberals. Recently, I shocked one of my law and economics friends by revealing that I wanted to develop a theory of rights to justify the present or any other distribution of property in the United States or elsewhere. He was good enough to hide his dismay, but I could tell that he was deeply offended by so heterodox an enterprise. That's theology, he intoned, and turned the conversation to some more fruitful subject, like the ability of capital markets to respond to product markets dominated by monopoly producers. He did not mean, by the way, that there was anything wrong with theology. It was just not his field. Surely, however, it cannot be right that I need to resort to God to find a justification for my right to be secure in my person and my possessions. While it is true that natural law and theology often find themselves in the same company, many natural rights theorists were Enlightenment rationalists and agnostics who vigorously eschewed the opportunity to locate natural law in God's will. I've dwelt on these matters perhaps a little longer than I should, because I think it is important to see how uneasy is the current alliance between libertarians on the one hand and free market economists on the other. Libertarians and right-wing economists both, and I believe rightly, extol the virtues of free market capitalism. For this brand of economist, that philosophy is to be embraced because it maximizes wealth or welfare. It comes to the conclusion that rational individuals can maximize their own welfare if left to their own devices. It is thus an individualistic philosophy, and to this extent, then, it has a point of contact with traditional liberal thought. But observe how different are the libertarian reasons for coming to the same conclusion. In the latter ideology, free enterprise is preferable because it embraces the individual's right to pursue his own brand of happiness, to go to hell in his own way, to keep people from poking their noses into their business, all of that kind of talk. Especially if those people are the government and thus have the ability to resort to guns and jails to enforce their interventions. In short, the inclination is to invoke something called the right to be left alone, a right for which modern liberals used to have a lot of respect, but no longer do. It goes without saying that many adherents of critical legal theory are equally disdainful of classical liberal values. No doubt, in its most vulgar form, this worldview would denounce these values as products of bourgeois sentimentalism or jackbooted individualism. But I do not mean to trivialize this group. They have very adroitly and usefully exposed to view the incoherence of much of modern liberal thought. Let me give my own example of this incoherence in order to make clear what I mean. It has to do with property. We continue to live, or at least purport to continue to live, under an 18th century Constitution that presumes the rightness of, and in some of its provisions gives protection to, the classical liberal values of contract and property. It is true that some anti-liberal facts, the most obvious of which is slavery, gave the Constitution a major part of its shape. But so embarrassed were its draftsmen that the word slavery never actually appears in the document. It is well known that on this score the Constitution most clearly reveals itself as a treaty between the states. Under the 1791 Constitution, in any case, member states were not to impair the obligations of contract, and the new government was not to take property without compensation. It is hard to imagine a set of propositions more libertarian than these. But look at what we have now. Alongside this distinctly classical worldview, ideas that still find fitful enforcement in our courts, has grown up a redistributive state that, among other things, regards something called need as presenting a claim to the nation's goods and services, which competes with and more frequently trumps the claim to them that the 18th century called property. To put the matter most bluntly, the taxing power has overwhelmed and rendered increasingly impotent the just compensation principle of the Fifth Amendment. That's all right. You can As far as freedom of contract is concerned today, it is denounced as a shibboleth or as Kabbalistic dogma in our courts and legislatures alike. In its place, appeal is made to a number of formless notions, the most common being the idea of unequal bargaining power, an idea so elastic and devoid of shape that it can accommodate any interventionist result. What our century has created is some kind of tertium quid between classical liberalism and state socialism. This social system, it seems to me, as a logical matter, is unstable, but the vectors of social pressure have reached a kind of equilibrium at the moment, and it's anybody's guess how long it can endure. Some critical legal scholars, at any rate, would probably see its classical liberal component as simply a mask for legitimating greed, hierarchy, and dominance, though they have not as yet offered anything that resembles a coherent alternative, not even state socialism, and this despite their occasional choice of Marxist words to describe themselves. In fact, I do not know a single member of the critical legal studies group whose views would find any favor at all with the members of leftist totalitarian states. In fact, I suspect that in the event of deportation to those foreign climes, the devotees of critical legal thought would very soon find themselves sent to the cucumber fields to develop solidarity with the world's oppressed peoples. Having indicated that libertarians in the academy have of late found themselves on rather unfriendly ground on all sides, it has come time to try to defend the proposition that rights in fact do exist and that something called the right of association is among them. At bottom, the aim must be to demonstrate that there are some things that a civilized government simply cannot do to its subjects. This will necessarily be hard going, and in the face of the powerful scientific and quantitative methods of the utilitarians, the necessarily qualitative talk of natural lawyers may tend to look foolish. Any assertion that liberty is a good in itself will inevitably bring the question, liberty to do what? Surely not to plunder and to maim. Who gets to make the list of the liberties that are to be protected? The answer to these questions will necessarily be descriptive to a degree and not analytical. Many items will owe their place on the list of liberties to the fact that they are analogous to others that might by general agreement seem to belong there. The right to association, including the right to exclude others, it seems to me, is a privacy/property right, and one which many people, including me, would find analogous to the right to make one's own guest list for a party, the right to choose one's own company. Hardly anybody would contend that a government ought to have the power to intrude into this situation with some suggested guests of its own. I know that there will be some who will wish to justify this result, justify by pointing to the demonstrable gains from trade that will accompany consensual transactions, and to the welfare gain represented by the sum of consumer surplus and seller profit that results. Those who are excluded, they will go on to say, suffer merely a competitive injury, and there is presumably some price at which they could buy into the arrangement. I find all this an insightful prop, but I do not find it personally necessary to resort to it in order to allow the transactions to go forward. For it seems to me a matter of right, like the one a woman has to choose from, say, 5 suitors, or indeed to choose none at all. I realize from experience that many people will not see this analogy. Instead, they will reject it as obviously wrong. I don't know how to answer that kind of criticism, but my experience too tells me that no amount of proof that efficiency gains are realizable from these kinds of transactions will move the skeptics to drop their opposition. I make no apology for the frankly unscientific character of this series of assertions. Natural rights principles simply are not scientific. They arise from attempts to apply moral and intelligent minds to facts and can have no other justification than their innate moral appeal. What I very much hope for my old colleagues in the university and for my former students is that right and wrong can someday soon make a comeback. Thank you very much.
It is 5:30, but the organizers say we can run over slightly if there are questions. Why don't you come down to the microphone?
All right, I'll address this one to Rocky. Looking at the structure of the Constitution, structure of the government that it establishes, history and tradition, really, honestly, truly, can't you make a pretty darn good argument that the the right of association is a candidate for the Ninth Amendment?
Well, it's like the right of privacy. Yeah, there are some contexts in which you can call some things association and privacy. I happen to think, by the way, that the Ninth Amendment does mean something, but probably not what Professor Barnett thinks it means.
That's
I think that it
I'm
means
setting you
that,
up for that one.
yeah, I think that it means that the federal government, you have to go to the Privilege and Immunities Clause to decide what rights are binding on the states. But as far as the Ninth Amendment, I believe it means that the federal government may not make any law that the people who ratified the Constitution in 1790 would have regarded as something that no civilized people could ever do. Blackstone's example is you couldn't make a law saying that A who's the wife of B shall become the wife of C, and so forth. I think that's true. I think that's what the Ninth Amendment means, that there are some things that just because they're so awful that we didn't think to write them down doesn't mean that even if the federal government could find it within one of the heads of powers, they wouldn't be barred from doing it. Privilege and Immunities Clause may mean something like that. And some things that are called association, I would gladly say, are within that rule. And there might be reasonable disagreements. I'm very reluctant to say that there is a general right of association which the courts then get to take over and decide which 20th century conceptions of it are correct.
Professor Barnett.
I think one of the interesting things about what you said, Grover, is that I think that today, if you want to be true to the original intent, you'd have to assume the existence of natural rights, even if you don't believe in them now. So that you'd have to say, well, let's see, now what did they think the natural rights were, even though we think that's a bunch of nonsense, and then we'll use that to interpret what the Ninth Amendment means, which in a sense, I guess, finesses the issue of whether we have these rights or not. So I think what you've just said would put us on the same realm of discourse, and then the only disagreement might then be as to the generality of the principles that were held then, and whether they are at all malleable into today's world, and whether how much room for play is there to translate them till now. But basically, that's what I liked about your comment.
Bruce Fine.
So I'd like to invoke Justice Holmes again, where he said in New York Trust Company versus Eisner that a page of history is worth volumes of logic, insofar as we seem to be elaborating on the Ninth Amendment. And I'd like to get Professor Easterbrook's, or Judge Easterbrook's, response to the history which demonstrates that the Bill of Rights, indeed, was viewed as dangerous by Madison and Hamilton and others because it would suggest that a government of limited powers, namely the federal government, might be deemed to have those powers, to perhaps say A is married to C instead of B, because it's thought that you're erecting barriers to power that was never conferred by the original document at all. And indeed, the Bill of Rights, and the Ninth Amendment included, was a political response to the political necessity to mollify some opposition in the Virginia ratification debates and the New York ratification debates and others who insisted that they just wanted the Bill of Rights there. But it was viewed by the drafters with great hesitation, because they thought, and I think they have been correct in their assessment, that by ratifying a Bill of Rights, it would then create a Leviathan with more power than was anticipated at the outset.
Well, I'm not sure exactly what the question in that is, Bruce. I agree that that was a major strain in the worry of the Federalists in proposing things, and I've always understood the Ninth Amendment as the principal response to that. It was a direct proclamation that things are not being increased, the government is not being given new rights to impinge on freedoms that were thought to be secured by the establishment of the governmental structure and a variety of other things that were done in the major part of the Constitution. I don't agree with the proposition that people have since taken the Bill of Rights to enlarge federal powers. Federal powers have gotten enlarged in very different ways, not through negative implications of the Bill of Rights, but through changes in the national economy. They've gotten enlarged in part because commerce among the states has grown dramatically with decreases in the cost of transportation. They got enlarged because of canals. They got enlarged because of railroads. They got enlarged because of telecommunications. They got enlarged because the cost of running a large country from a single little city on the East Coast went down dramatically. All of those were things that had nothing to do with the Bill of Rights and which we would be grappling with today, were there a Bill of Rights or not.
Professor Barnett, Judge Arnold, just how do we, as a democratic process or a legal system, determine when the rights of the states, of the people of the states to regulate health and morals and safety, when do those rights stop and so-called natural rights begin? How do we draw those lines, and who draws those lines?
Would you please go first?
Well, obviously, as I said in my talk, I don't think there are easy answers to these questions, but I know as a person who primarily studies private law areas, contract and property and torts and that sort of thing, they're not easy lines to draw either in those areas. But yet these are whole bodies of thought that are attempting to trace what rights individuals have when they are dealing with each other. And I think the only thing that you would have to do over and above analyze what the private law rights of everybody is to figure out when, if ever, does government have the right to do something that other people, normal people, don't have a right to do, which is the methodology of Richard Epstein's recent book. Whatever you may think of any particular proposal or constitutional doctrine he suggests there, the methodology is to start with a paradigm of private law rights which is much older than the Constitution and which has a primarily judicial creation, and use that as a quite intricate and complicated baseline against which you judge the acts of people who are part of your government.
I quite agree, and it seems to me that, as always, history and logic are the best guides. I would like to say, however, that I have exhausted my ability here today to tell you much about natural rights because I limited myself to this topic. I don't know that there are other natural, but I know there are, and I know what some of them are, but I'm not telling you today. You'll have to invite me back. But I simply wanted to limit myself today to a discussion of a social right of association. There are all kinds of other rights of association that are problematic. Criminal conspiracies, cartels, I think those are very difficult questions. As I said, I think that it really merely requires the application of a set of moral and intelligent minds to facts, history and logic being the main guides. I also did not commit myself to any position that the Constitution incorporates anything like natural rights. I think that's a much more difficult question and a technical one, which I don't have a lot of expertise with. I wish, as Professor Friedman last night said, that there was a provision in the Constitution that said that all acts between consenting adults were constitutional, but there isn't any such provision, and we're just going to have to limp along with what we've got, I guess, for the time being.
Go ahead. Let me ask Judge Easterbrook, what substantive rights, if any, do you think are protected by the Ninth Amendment?
I'm sorry, I couldn't hear
What substantive rights, if any, do you believe are protected by the Ninth Amendment?
By the Ninth Amendment? I don't think any are protected by the Ninth Amendment.
Well, what does it mean then?
I think I've already given my understanding.
Well, you've given the historical explanation, but I don't
Yes,
think.
that's
What
what it
is there
means.
any present meaning within it? Would you agree with?
That one cannot use the other parts of the Bill of Rights to argue for an augmentation of federal power. You cannot say that because it was necessary to have this set of controls on speech, therefore it follows that Congress has some power over speech, and it turns out that that power is whatever was not forbidden by the First Amendment. That form of argumentation, which at the time the Bill of Rights was created was a very common form of legal argumentation, was to be foreclosed as a method of analyzing the governmental powers created by the Bill of Rights. I think that was what its function is.
Well, if we had a government of enumerated powers at the outset, and the Ninth Amendment specifically refers to other rights that were not identified, what other rights were they referring to that are retained by the people?
the rights not to have the government regulate unless the power was granted. That is the right that was retained by the people. And that when you create a government of limited powers, what you're retaining is all the powers not granted. And then you're very worried whenever you write something down that somebody is going to take that as a grant of powers.
Just a hypothetical question, then a real one. I wonder if the Federalist Society will be someday struck by a Supreme Court decision saying we discriminate against communists or the like. I'd like to direct the real question to Randy Barnett for the sake of the philosophical background. Let's say I start a business. Let's say I start a business, I order the inventory, I hire employees, I run the business completely. I would maintain, well, that's part of my property. The business belongs to me. I call the shots, I put out the money, it should belong to me. If I choose to fire an employee, and the employee files suit, and a judgment is with the employee saying I have to hire him back, or whatever, I would say that my business has been degraded. It's been depreciated. And I should get just compensation for keeping a lousy employee. I'd like some philosophical background on that.
The issue, in my view, would be whether you had a contract of employment with your employee. If you had no contract of employment and the arrangement you had was an at-will employment arrangement and there's no misrepresentation as to what it is, then you can fire the person for no reason, for bad reason, for whatever reason. In my view, if you have a contract, then you might be in breach of that contract and you might owe damages. That's not very philosophical, but it's legal.
My question concerns the so-called practice of law and advocacy in court in relation to associations. And I remember Professor Bator especially distinguished whether he'd have a decision by a legislature as distinguished from a court. And suppose in relation to associations that 1,000 people say we would like to have this person our advocate, and that person goes to court. And a judge says, but you are not a licensed attorney. Now, who can decide who should be whose advocate? Should the 1,000 people be able to choose their advocate? Can you reconcile a licensing of advocacy with the First Amendment? This is not to say that training in law and license may not generally promote skills in advocacy, but there are other modes of learning. There are other criteria by which people may want to choose their advocate. Can a group of self-perpetuating people decide who shall be the advocates for everyone, or shall the people, especially in concern with the growing public sector and control, be able to say your advocate in suits against the government shall be somebody that the government licenses?
Who would you like to answer the question?
I would appreciate an answer from anyone who's willing to tackle it, and everyone.
Well, I can say a couple of things about it. First, if you start looking in the Constitution for where there is a right to be represented by a lawyer in court, it turns out to be only in the Sixth Amendment and only for criminal cases. There isn't a constitutional right to be represented by a lawyer in civil cases. Then you might have to decide what it means to say a lawyer. It turns out that this is yet another case where history speaks volumes, and it's a very brief history. At the time the Constitution was created and the time the Bill of Rights was created, lawyers were then licensed by courts. Somebody who claimed to be skilled in the law would go to a local court, would receive the permission of the judge to practice in that court. And I think it would be very unlikely that that uniform practice in the colonies and in the fledgling courts of the United States was meant to be held unconstitutional by any of the clauses. That one can learn enough from the practice at the time to know the right answer to a question such as that.
It's not, excuse me, but my question is really not the historical preface, but as been pointed out in these panels, things have changed very much in communications, in the role of how much the public sector is, and what's left for the people under the circumstances. So it's really maybe a question of whether law should be considered for deregulation as far as the choice of advocates, or that the people may have a right to associate that can be effectuated through through courts too.
Well, I wasn't implying
Thank you.
for a second that this might not commend itself to the legislature, either in the states or in Congress. And I was limiting myself to what the Constitution of its own force compelled, and the answer to that question is short and sweet, nothing.
Yeah. We have just a few minutes left, so we'll go to this question here.
May I have another answer, please?
We'll go to this question. Really, to be fair to everyone, we need to go to the different questioners. Go ahead.
Professor Barnett, I think most Democrats, and that would be with a small d, would agree that the first right on anybody's list of natural rights would be that of self-government. And given that, it seems that your view presents a paradox. Apparently, if a people have a right of self-government, then they also have the right to deprive themselves of any other rights that they choose to, excepting those that they bound future generations to, that is, constitutional rights. So how would you square that paradox with your views that there are natural rights extrinsic to the Constitution that the people cannot agree to deprive themselves of if they choose to?
Well, I'm not exactly sure I'm really not exactly sure what you're exactly pointing out, but I should say this. I think that we have some rights that are unalienable or inalienable. There are certain rights that we have that cannot be transferred even with our own consent. And that's not that is a controversial view in philosophy. There's a lot of debate as to whether can be such a thing, but it was not that controversial at the time of the founding of the government. So, okay. I mean, I'm not sure. I just don't know exactly where you're coming from.
Okay, Judge Easterbrook, it would be your job, I'm sure, to find out, to reach out and find those natural rights that Professor Barnett is talking about. I'm wondering how you go about doing that.
Not on the basis of my talk this afternoon.
No. I understand you don't subscribe to that. As a judge, how would any judge go about doing that?
Poorly.
Thank you.
I think what Professor Barnett and Judge Arnold said about natural law existing and natural rights existing is obviously true. And I agree entirely with Judge Arnold that a right to associate is one of the rights contained within the natural law. The question I wish Judge Arnold had gone on to address was, which I think is the more topical one, is whether that right to associate which exists under the natural law happens to be among the rights which were also secured within the positive law under the United States Constitution. It's tempting to turn to the Ninth Amendment as a possible source, as a possible provision that secures that law. And frankly, I think the right to associate may well be among those which the framers of the Ninth Amendment had in mind. The problem with the Ninth Amendment, and this is something, it really eludes me why people seem to look at the Ninth Amendment the way they do, and I suspect it's symptomatic of legal training. We saw a symptom of this earlier when somebody said, the mayor was, Larry Tribe said it was unconstitutional for this mayor to veto the provision rather than allow the courts to pass on its constitutionality as is the right of judges. Most of the provisions of the First Amendment seem to be directives. I mean, most of the provisions of the Bill of Rights probably are directives to judges, but they are also directives to legislators. And it is that second quality of those amendments that is often overlooked. In part, the First Amendment, it may well be a directive to the justices of the Supreme Court to strike down at least federal laws which establish a church or prohibit free exercise of religion and so on. But first and foremost, the First Amendment is a directive to Congress not to go and pass these offending laws in the first place.
Does someone wish to respond?
In that light, the Ninth Amendment seems to be unique in that it's a directive only to legislators. Sort of says, we all know from reading the document that the framers of the Constitution believed in natural law and natural rights. They seem to be saying, hey, there are these other rights which we haven't spoken about. Don't go and violate those either. So for Judge Arnold, is the right to associate secured within the positive law of the Constitution? And for Professor Barnett, is there's any reason Well, why does he think the Ninth Amendment speaks to judges as well as to Congress?
Well, I don't know whether the right to social association is in the Constitution or not. I did look it up in the index, and I didn't find it, if that's any help. I'm not clear how I feel about, first of all, the technical matter of what the Ninth Amendment means. I don't think I see your distinction, by the way, between amendments that speak only to the legislature and those that speak to the legislature and the judiciary. I understand what you're saying, but I don't see why the Ninth Amendment is not equally addressed to both branches of government. Secondly, I have the same difficulty that Judge Easterbrook has with doing anything real with what I've had to say, and that is that I think judges are, by and large, likely to be pretty poor at choosing correctly among the possibilities of natural law. Even me.
Well, I think that's true. That's why we see such bad contract law, we see such bad tort law, we see such bad property law. Judges make mistakes, and it's a product of their inadequate legal education. So if you want to put the blame anywhere, you got to put it right where it belongs, with the law professors who started a lot of these crackpot ideas in the first place.
May I just say one more thing? The J.C.'s case that was alluded to 2 or 3 times today came up from the Eighth Circuit Court of Appeals in the opposite configuration from the way it went down. In other words, the Eighth Circuit Court of Appeals had upheld the J.C.'s right of association and had struck down the statute that had been interpreted, at least, to require them to accept women members. The majority opinion was written by my brother, who's Richard Arnold, and who is on the Eighth Circuit Court of Appeals. So you may, if I were to sit on such a case as that, that might be some indication of how I would come out.
Can I comment also on, it seems to me that Judges Arnold and Easterbrook have both committed the error, a species of the error that Judge Arnold accused law and economics people of, which is that implying that we shouldn't do this because judges wouldn't be good at it. As Professor Barnett, I think, is sort of getting at, well, if they're not good at it, but if it's what they're supposed to do under the Constitution, they should either resign or get better. It seems to me there is another problem, though, which is a hard problem, which is whether, given that I really believe something is a natural right, I nevertheless would think if I were a judge that I had a right to enforce it. I mean, there are some things that I'm pretty sure I think are a natural right, that I'm pretty sure the framers of the 1790 and 1868 provisions of the Constitution neither wanted to make binding on people and legislatures, nor wanted to give courts the power to make binding. And so you have that question that is a question about judicial review, which is who's we paleface? That you have to confront at that point, and that is a severable question from what you think natural rights are, and it's got to be.
Final question.
Thank you. Last night, in response to a question, Judge Bork said that the reason that we care about original intent is that without looking to the intent of the framers, then a judge will only look inside his own soul. To take advantage of Judge Bork's absence, I think the response is too simple because it's mutually exclusive. Because if we dispute the fact about the derivation of natural rights, then I also dispute the ability of us to divine the intention of the framers on a lot of things. And as we have often quoted Jefferson and Madison, I would like to bring up something that has been obscured so far in this conference. To paraphrase Jefferson, that we shall not be ruled from the grave. So why is it imperative upon this body to constantly look at the intent when a lot of this looking is nonsense on stilts? And the thing that I would like to suggest as a good example is the Lochner decision. We already know that Professor Epstein thinks that Lochner was correctly decided. Professor Barnett has indicated that he thinks that Lochner was correctly decided, and he brings out John Locke to defend his position that Lochner was correctly decided.
Who would you like to comment on your position?
Let's start with Professor Barnett, please.
Okay, Professor Barnett, thank you.
There was no question. There was a question that I thought Frank was going to take.
Well, I'll be happy to say something. Ex-professors are happy to say something about anything at the drop of a hat.
Only if they're approaching
there are
retirement.
there are a couple of responses. One is that Jefferson's proposal to put a sunset clause in the Constitution was not adopted. Jefferson thought that each generation should choose its own Constitution, but he lost in that debate. The second proposition is something that I would like to turn around. The question is not so much why we should be ruled by our forebears and dead hands and the like. Harder question, the one we have been really looking at in this conference, has to do with the kinds of statements judges must make when judges call on the political actors to desist from the outcome of the political process and insist that some other claim be substituted. And why is it that when a judge says, I think X is a natural right, or I think the freedom of association means Y, anybody else should give any attention to that? Because if the judge writes it down in a law review, or a professor of law writes it down in a law review, everybody will take it as an interesting exercise, an appeal to reason, a discussion of how government should behave. When a judge writes it down, other people are supposed to hop to it. Now, the first reason why the judge gives why other people are supposed to hop to it is precisely that we are being ruled by the framers from the graves, that there is a provision in Article 3 which has been construed in a particular way in Marbury against Madison, and there is this consequence, which is others should hop to it when judges do that. If you don't believe we should be ruled by the framers from their graves, there is no reason why anyone should pay any attention to judges. Second, there is a question about what kind of claim judges have to give to induce others to hop to it. And that kind of claim will not be sufficient if the judge simply says, I have a set of political, philosophical reasons, or as John Ely put it in his book, I like Rawls, you like Nozick, there are 6 of me and 3 of you, statute invalidated. That won't be viewed as an acceptable claim. The kind of claim the judge has to give if he wants to make a legitimate demand to be obeyed has to be a claim to a decision that is made externally by sources that can be verified in a particular way. That sort of claim is almost always a claim about the original meaning of a document written by people now dead. And to the extent one moves away from that claim, even if you believe that there is such an institution as judicial review, the judge hasn't stated an adequate reason within the scope of that institution to demand that the political decision be displaced. And all of that, of course, suggests an exceptionally narrow scope for any form of judicial review of political decisions in the name of anything other than the original meaning of a document written by people now dead.
Professor.
Professor Barnett will have the last word.
I don't want to, I don't intend by my remarks, my brief remark, to cast any aspersions on original intent as a theory of constitutional law. But I do think that, I do think Professor Easterbrook, Judge Easterbrook's statement went a little too far. People have been hopping to the orders of judges for centuries before there ever was a written constitution. They're still hopping to the orders of judges in countries that don't have written constitutions, like Great Britain. And these judges have authority, and their authority is based on right. That's the nature of their authority. It's not, and so I distinguish between authority and power. Certain things empower judges to do certain things, and certain principles authorize them to do it, and it's a long-standing tradition that is older than our constitutional tradition.